Mr. Steve Madsen is representing Ms. Evans. Mr. Madsen, are you on the line?
Sure. Thank you very much.
Okay, there is. Yes, go ahead.
Okay. Your Honor, this is similar to a matter we submitted in another case. Mr. Evans has never appeared in this matter, has never responded to any of the petition, which resulted in the decree of dissolution. Likewise, he refuses to execute the quitclaim deed as required by the decree of dissolution. We're requesting that the court order a special master to execute the quitclaim deed and real estate excise tax affidavit on his behalf in order to complete the court's order and finalize the dissolution.
Thank you, Mr. Madsen. I'm just going to call, for sake of completeness, Joshua Evans. Joshua Evans, if you're on the line or in the court, please make yourself known. And Mr. Evans, if you are on the line, I'm not able to hear you, so make sure you're unmuted. If you're dialing in on a phone number, make sure you press *6. That'll mute and unmute alternatively. Otherwise, press the microphone icon. I don't see anybody on the Zoom call that has a name that's similar to Josh or Joshua Evans. And I'll just, for the record, Lindsay Evans is on the line. I see that she's present also.
Yes.
So with regard to that, the motion to appoint a special master, having reviewed the motion in the file, that seems appropriate. And I just want to ask Mr. Madsen, is it your sense that I'm thinking of appointing Commissioner Jill Carmy to act as special master? All right.
That's perfect. I already have, as the court's seen before, we've easily drafted a quitclaim deed and real estate excise tax affidavit that the auditor's office, the treasurer's office have processed previously. So I see no issues with that.
Okay. And then you submitted a couple of documents for the court's review, and there's an order appointing special master. I have that here, and I'll just fill that out and I'll add court appoints Commissioner Jill Carmy. Okay, so I've signed that, and then you can take steps and get that taken care of.
Thank you, Your Honor.
All right, thank you very much. Sandy, present, representing Kyle Menning. And is Mr. Menning on the line?
Yes, Your Honor.
Okay, welcome to you. And then looks like then Jennifer Powers, are you on the line? Jennifer Powers. Oh, there you are. Come on up, Ms. Powers. And I believe Ms. Looney. Ms. Looney, are you on the line?
I am, Your Honor.
Okay, great. And Ms. Looney represents the state. This is a motion related to temporary child support. And I failed to note the moving party. So if the moving party just wants to lead out, that would be great.
It's the state, Your Honor.
Thanks.
We are here on our motion for temporary child support. We had previously requested that child support would be reserved when the case was moved to mediation because the children are receiving TANF. So we have filed a proposed order. Mr. Sandy did recently file a notice of appearance, and he also has provided some additional proposed worksheets and information about Mr. Menning's income that was not available to the state at the time that we drafted our proposed order.
Okay.
So we had information only as to 1 quarter of 2023. We would not be in disagreement with using Mr. Zandy's income information and calculation for Mr. Menning regarding his income. We do believe that our imputation of Ms. Powers at the TANF wage of 32 hours per week minimum wage is still appropriate. So we'd be requesting that those incomes be used for the child support order.
Okay, and so the imputation as to Ms. Powers, you're recommending $2,035 net?
That would be the net income, yes, Your Honor.
Okay, and then for using Mr. Zandy's numbers, his net would be, it was in the 6,000 range, and
I believe it was 6,062, if I'm not mistaken.
That's correct.
Okay, 6,062. Okay. And all right, thank you. And anything else, Ms. Looney, with that?
No, Your Honor. If Your Honor is agreeable to using those numbers, we would be drafting an updated order and asking to have a presentation date.
Okay. All right. Thank you. We'll hear from Mr. Zandy, then we'll hear from you, Ms. Powers.
And thank you, Your Honor. Court's aware I do represent the respondent, Kyle Menning, and I do think that our income calculation for Mr. Menning is appropriate. I think the difference initially, and my client did a good job of providing the documents to verify his position, is related to him working in New Mexico and on a per diem heavy overtime basis for approximately a quarter or a quarter and a half of last year, which is where I think the state came up with their initial figures. So as we've detailed in our declaration, the information that we've provided, that was pretty much a one-off. Now that was an opportunity that my client took advantage of to work in New Mexico. but so far it's been a once in a career thing. And you can see from his traditional earnings, and we've given you tax information dating back to 2019, his 2023 income was significantly more than he traditionally makes and significantly more than he's on track for 2024. So a couple ways to do it. I think it gets us to a similar spot. You can take his hourly rate of the $52.05 per hour and extrapolate that, or alternatively, which I did, which puts again you at a very similar place on the worksheets, is just take his year-to-date wages on his March 9th pay stub and divide those out by the 2.33 months, and that's where we arrive at our gross monthly income of $8,667, or a net, as Ms. Looney indicates, of $6,062. So I think that is much more accurate of what he earns. And as the court typically says, there's just simply in a divorce case, oftentimes not enough money to go around. My client's doing all he can to pay the bills to maintain essentially two households since he's separated, and getting the support correct in the child support angle is, I think, important for everybody. So we do believe that income calculation is correct. We're asking you to use that on the worksheets for my client. If you look at Ms. Powers, and again, this was somewhat, and Ms. Lydia is again correct, my involvement in this case is very new. So I haven't had time to actually exchange discovery or make additional requests for income of Ms. Powers. But initially, what we do believe is that she's living with another adult in the house who is a welder, income producer. Also understand that she is capable of working and actually does have a couple of small businesses making custom shirts and doing some things with dog breeding. And she's present in the courtroom today, it looks like, so she can give additional information on that. Not opposed to using whatever is reasonable for imputation of income. We simply took the route of imputing her at the national median income level, which again is a net of about $3,200 per month, or a little bit higher than what the state has proposed with just the basic minimum wage order. So that's kind of our spiel on things. That's what we're asking the court to do. And mediation is forthcoming. These folks will be in mediation shortly, which again, hopefully they can make some resolutions on that, get at least the parenting plan figured out. But for now, getting an accurate income assessment for both parties, I think, is imperative.
Okay, great. Thank you. Ms. Powers.
So I'd like to start off by saying that in his declaration, he claims that I largely choose not to work. That is completely inaccurate. We have two special needs children, one that I have custody of, that I got custody of while I was with Kyle. He's in special education. He takes a lot of time. I also have a special needs son that Kyle and I have together that we almost lost in 2022. He's in a special education program. Every time he hits his head at school, I am called, I am expected to be there and ensure that his well-being is met. So I also have a 16-year-old daughter with Kyle who is homeschooled. So it is very unrealistic of him to think that I can do more. I've been a stay-at-home mom for the entire time that we've been together, which is 23 years since I was 16. I only have a GED and no further schooling or work experience. I did the best that I could to get a job as soon as I could. As soon as I was done with my health back, getting my health back in order, including surgery on my leg, I got a job. I ended up getting lucky thanks to a friend. He gave me a job starting on 11/7/2023. He hired me and has been helping me learn to do the necessary things for the job. The job I currently have is very crucial, as I have the ability to leave every time I get a call from the school saying our son has hit his head or is sick. I'm a single mother trying to raise two special needs boys and a daughter who's homeschooled. Working more than I am now would hinder my ability to properly care for the three children. So by him saying I should be able to make $3,200 a month and not choosing to work is absurd. His accusations of a shirt business and dog breeding would have been true back when I was able to do those things. I can submit proof that the dogs have been finding new homes and the website has been shut down for some time. As for the shirt business that he's claiming, that was a side hustle that our daughter started to help pay for her horse activities. Her Facebook page has been inactive since 3/8/2022. I do have plans to go to school to further my education. However, with the fact that I need to work and I'm not receiving any help, it makes that impossible. Our 16-year-old is doing the best that she can to continue her education at home with her homeschooling program, as well as getting our son on and off the bus so that I can work. I am not getting child support. I'm not getting spousal support. I cannot pay more than the bills that I am already paying without getting those things. So for him to say that I can do more is absolutely heartbreaking. I have asked for help with things that the kids need that are necessities, and I've continuously been told that he cannot afford it. But he now has the money for an attorney, and he's paying off bills consistently, which I can see on his Credit Karma. It's very heartbreaking to me that I feel like I have been left to pick up all the pieces of two parents and do everything. I'm taking them to their doctor's appointments, their counseling, school, whatever they need. I'm doing it all. He just sees our son every Wednesday night and every other weekend. He does not see our daughter, and he does not provide any care. He expects that I send clothes in the proper size for our son every time that he has visitation, has not bought any clothing for him. But when I ask for help with clothing, because he's
not part of the court record at this point. Again, I'm new to this case. I didn't see any declarations that were filed by Ms. Powers on her own behalf. And this is obviously new information. I think some of it is irrelevant to the issue today. So we just ask that you consider whatever's contained in the file.
Your Honor, I did not receive this paperwork from Kyle's attorney. I received it in the mail on Monday at 4 p.m. when I got off of work. I check the mail every day, so I know it did not come until Monday. I got off work at 4 p.m., received this. That has not given me enough time, considering in that time frame, I have been at work on Tuesday all day from 4 a.m. until 4 p.m. And then our daughter had her high school equestrian practice at 4:30 p.m., at which we got home at 8:30 p.m. I had to put the children to bed. And then I had to get up again this morning, and I have barely enough time that I had to write something up to be able to speak in behalf of all of these accusations that he's making. So I have not had significant time to be able to present you with anything.
So let me, I appreciate that input. And let me ask you kind of the salient issue before us is Ms. Looney and is proposing some dollar figures for net income, gross incomes for both parties, as is Mr. Zandy on behalf of his client. What is your response, or what is your viewpoint related to that?
I agree with Ms. Looney that with due time and a little bit of help that I could be able to work the 40 hours at minimum wage, or 32 hours, what she's proposing. It's challenging on my own without any help, but I am doing the best that I can. And I do agree with her assessment that with a little bit of time, I can make more money. And I do believe after that, I could make more than that. I just need to go to school, which right now is just super challenging.
So her figures of, the roughly the 3,000 gross and 2,035 net, you're not in disagreement with?
I'm not in disagreement with her. I think that that's fair to say.
And then regarding the figures for Mr. Powers as to his gross of 8,700 and a net of around 6,000, 6,100. What's your opinion on that?
My opinion is, yes, I agree that New Mexico was a once in a lifetime opportunity. I believe that he is only working 40 hours because he's choosing to, but that is what he wants to do. That's fine. I'm not going to disagree with it. I'm happy to get whatever help that I can get for our kids. So.
Okay. All right. Great. Thank you. Appreciate that. Ms. Looney, anything else?
Nothing further, Your Honor.
Mr. Zandy, anything else?
No, I just mentioned that as the obligor, I think that income, and it sounds like all three of us are agree with that, which is certainly terrific. I think that's kind of what sets the support. Now there's going to be a little bit of variance with that bottom line number between the now roughly 2,200 that the state has for full-time minimum wage and the 3,200 that we have calculated. But again, this is a temporary order, and I don't know that that's going to make a huge significant difference. So whatever the court needs appropriate for that is certainly something that will, I think, both parties, all three parties, will live with.
Okay, thanks. So this, the motion is for temporary child support, and there's a lot of different issues that surround child support, obviously care of children, special needs, and the like, and work flexibility. All those things come into play, are a part of it. The main focus of today is the dollars, just simple dollars. There's no strong disagreement, I think, from any of the parties that will set Ms. Powers her net income at 2,035 imputed because she's taking care of the children, and that has value. And then they'll set the the net income for Mr. Powers at 6,062. I think his W-2 show that definitely that 2023 year was an aberration. He's been averaging roughly 100,000, 95,000 there, $100,000 level. And especially at the 52 an hour, that pencils out. So we'll adopt those numbers: 2035 for net for Ms. Powers, and 6062 I think was the net for Mr. Menning. And as far as a start date, Ms. Looney, you were requesting a February 1 date. Is that correct?
Your Honor, actually did write look at that, and we actually had a slight clerical error there. The children began receiving TANF in January, so it would be January start date that we would request.
Okay. And Mr. Sandy, do you want to address that, and then we'll hear from Ms. Bowers?
Yeah, I think the only issue that we would have with that is it's going to create potentially a little bit of havoc on the balance sheet when they actually do complete the divorce. My client has been paying pretty much all the community bills, including the mortgage, I believe, which is certainly a form of support. I understand that the state is not going to necessarily look at that and calculate that as part of their order. But what I would ask for is that the court reserve on any reimbursement issues related to what my client actually has paid on behalf of his family, and most specifically these kids, since the first of the year. That's first and foremost. Secondary to that, I would just ask that any tax exemptions be likewise reserved in that temporary order of support. And if these parties can't be divorced by the end of 2024, then we can come back on that issue if need be.
Thank you. Ms. Bowers.
So I do agree, and I have sent multiple messages to Kyle and thanking him that he is still paying the mortgage, as well as our truck payment. Our truck is how I get hay for our daughter's horses and try to continue her activities. I am paying everything else as far as the household goes. But I did receive a letter in the mail showing that the house is not being paid and it is in pre-foreclosure. So I would beg to differ that he is continuing to pay the home payment for the home that our children currently reside in. And as I stated in my original declaration to you, Judge, that house is very important because it keeps both of my boys in the same school district that they are in the same school special education programs that they're in. So it is very crucial that we be able to stay there. The school district for my youngest boy is very small, and there are no rentals or homes for sale that I could even remotely qualify to get in order to keep him in the same program that he's in. So I would beg to differ on the continuing to pay the home payment. And the way that I kind of saw that was like, he hasn't helped since August with any child support, any necessities for the kids, or any spousal support. So I was kind of seeing that as he was doing it that way, I suppose.
All right, thank you. All right, having set the net incomes, then the last item to finish is the start date of the child support obligation. It'll be February 1st. February 1st, 2024 will be the start date. I'll reserve the issue of tax exemption, so that can be raised at a later date. And then also the issue of any reimbursement of funds that have been potentially paid that could qualify as support, that can be reviewed at a future time. But otherwise, February 1st will be the start date. So that means, Ms. Looney, you'll be preparing those orders and submitting that to the court.
Yes, Your Honor.
Okay, I appreciate that. And so let's set a presentation date. So basically, Ms. Looney is going to prepare an order and also worksheets that include the net incomes I mentioned and the start date. She'll distribute that to Mr. Zandy, distribute a copy to you, Ms. Powers, and then we'll be back in roughly 2 weeks. And let's take a look at the calendar. It's 2 weeks.
Your Honor, this date would be unavailable on May 8th.
Okay. And it looks like on the 1st, that's judicial conference, so we're not having any hearings on that day. So the next available date would be on the 15th of May. So just to see if Mr. Zandy, does that work for you?
That's fine. And I anticipate we'll probably get an agreement order. I'll more than likely sign off on that prior.
Sure. So Ms. Powers, so when the proposed order is sent to you, if you feel like Ms. Looney got it right, she accurately portrayed and summarized what the court ordered here today, you can simply sign off on it and say, yeah, that's what the court ordered, and then just return it to her. If you disagree and say she got it wrong, then don't sign it, and then we'd be here on the 15th of May to talk about the disagreement. However, if there's full agreement, we would have that date set the 15th of May. But if there's full agreement, everybody signs off on it, then we just enter the order and then we strike the hearing on the 15th and nobody comes to court on that day.
Okay.
Okay. Any questions on that?
No, thank you, Your Honor.
Okay. All right. Okay. So that'll conclude the hearing. Thank you all.
Thank you.
And
Thank
James
you.
Riley matter. All right. It looks like Miss Riley is present in the courtroom. And you're-
James couldn't figure out the Zoom. He
okay.
couldn't download
I'm over
it on his
over the phone.
Oh, we got it. Okay, never mind.
All right. So Shaylin Riley is present in the courtroom. And then Mr. James Riley, are you on the line?
Yes, I'm here.
Okay, very good. All right, so I see that we're on today for a presentation of orders. Looks like both parties signed the findings and conclusions of marriage document, both signed the final divorce decree, and the parenting plan was signed by both parties. Then, and I failed to mention that Ms. Looney's on the line to welcome Ms. Looney.
Your
And
Honor.
then the only thing that I saw was that the child support order was only signed by the state. So just want to touch base with the parties on that. So just want to confirm, Ms. Riley, you're comfortable with the court signing off on the parenting plan order, the final divorce decree, and the findings and conclusions of marriage document.
Yes, sir.
Okay. And then Mr. Riley, same question to you. Are you comfortable if the court signs off on the parenting
Yes.
plan order, final divorce decree, and the findings and conclusions about a marriage?
Yes, sir.
Perfect. I'll sign off on those. Then the proposed order of child support and worksheets, those were prepared by Ms. Looney. So I'll ask Ms. Riley, did you get a copy of those documents?
Yes, sir.
Okay. And what's your position regarding those?
I agree with all of it.
Okay. All right. And then Mr. Riley, what's your position on the proposed child support order and worksheets?
I agree with all of it.
Okay. I guess I'll get my pen out and sign. I don't hear that there's any disagreement with the orders as proposed. Mr. Riley, do you have any questions?
No, sir.
Ms. Looney?
Nothing to add, Your Honor.
Ms. Riley?
Nope.
Pen's coming out. Okay, so I'll sign it. I'll sign all those documents. We'll get those filed. If you need copies of the documents, you can check with the clerk's office and get copies.
Okay.
Okay.
All right.
So with that, we'll conclude the hearing. I'll just sign and then we'll call the next case once I've finished signing.
Okay.
Thank you, Your Honor.
We're divorced.
Perfect. Thank you.
Yes, when I sign the final divorce decree, that's the official end date of it all.
Okay. Thank you so much.
All right, thanks.
Thank you.
Mr. Ruby is in the courtroom with us this morning. Welcome, Mr. Ruby.
How's it going?
And I'll ask if Ms. Granzo Carranza is on the line. Samantha Granzo Carranza, if you're on the line, please unmute and state your name. I'm going to take a look at the Zoom call listing of participants. Okay, I'm not seeing indication that she's there, and there's nobody in the waiting room, nor seeking to be admitted. And Ms. Looney is here representing the state. This is a motion related to a variety of temporary orders, transfer of mediation, the case to mediation, and restraining orders, the like. And we were here last, how long ago? Was it a couple?
2 weeks ago, and
2 weeks
then
ago?
2 weeks prior to that.
Right, right. So we've been here a couple of times, and I'm just going to pull up in my notes here to confirm when we were here last 2 weeks ago. Both parties were here.
Yes, sir.
Mr. Ruby is here, Ms. Granzo was here, and we set the matter over to today.
Yes. She was here 2 weeks ago on the 3rd too, and the judge, I don't remember his name, told her she didn't have the paperwork turned in for her response on Friday,
Mhm.
that it was just gonna go my way.
Right. Have you had any contact with Ms. Granzo?
None. She knows where I live. She
Okay.
could have mailed me anything, gotten a hold of the kids at any time, nothing.
Okay. And then Ms. Looney, have you had any contact with Ms. Granzo related to today's hearing?
No, we have not, Your Honor.
Okay. All right. And then let me just double check with Ms. Looney first, if I may. Ms. Looney, as far as your input on the pending motions, do you have any input on them?
None directly, Your Honor. Seeing as Judge Warning did state that he would be granting the motions if Ms. Granzo failed to file a response and appear, the state would just be requesting, if custody is changing today, that a short bench order be entered that states that Mr. Ruby's child support obligation would be ending today. Also, we're not sure if he's still requesting to go toward mediation, but we would ask that child support be reserved for mediation, and the state would be handling the order on that as well. Excuse me.
Okay. Thank you. Okay. So double checking with you, Mr. Ruby. Ms. Looney indicated that, if custody has changed, then your obligation to pay any child support would end today.
Yeah.
Any disagreement with that?
Nope.
Didn't think so. And then as far as mediation, if the court grants the motion to move the case, transfer the case to mediation, the state wants to be involved on that and just preserve on child support. So that could be a topic of conversation.
That's fine.
Okay. And so, okay, I'm just looking over my notes here, a couple of different things. So the February 13th, I just need to pull up again the February 13th restraining order, make sure that's clear in my mind
Okay.
of what that is and who's the restrained party. So it restrains Ms. Granzo. Okay.
sir.
All right. Okay, so I'll grant the motion. I'm not sure where Ms. Granzo is. She had an opportunity to file documents between 2 weeks ago and here. Nothing's been filed, and there's been apparently no contact between her and Ms. Looney and Mr. Ruby. So I'll grant the motion and designate Mr. Ruby as the primary custodial parent. And that if I'll award Ms. Granzo 2 hours per week of professionally supervised visitation
Okay.
on a temporary basis. And because of the change of custody, today ends any child support obligation. It ends today.
Yeah.
Yes.
Is there any way I can add that we do like UAs before she sees the kids? Because that's the main reason they wanted to come live with me, is they were tired of their mom doing that stuff and them seeing it all the time.
Right. Yeah, that's a good topic to talk about. So what I was thinking, and we can maybe just kind of work this out, is that if it's a professionally supervised visitation specialist,
Okay.
they don't allow people that are high to interact or move forward with any visits. So if she shows up high to a visit, or they suspect that she's high, they're not going to let it happen.
Okay.
So I think that provides the safety for the children. Are you comfortable with that?
Yep.
Okay. I do want to do one thing related to a family court investigator. I want to get a little more detail and information about what's going on with the kids.
Okay.
And the family court investigator, her name's Jen Schaefer or Jennifer Schaefer.
Okay.
So she would be, I would appoint her. There's no cost to any party. She would prepare kind of a quick report, do an initial investigation, and be back here in roughly 4 to 6 weeks.
Yeah.
Just to make sure everything, if we set up the parenting plan like we've set it up, where it's very limited visitation, she can give us a little input about how things are going with you and the kids and the like. So if you feel comfortable with that, okay. So let's do that. So I'm just going to make
Your Honor.
Yes, Ms. Looney.
I apologize, Your Honor. When we were here last, it was noted that Ms. Turnbull was still appointed as the guardian ad litem. Her order appointing did not have any stipulation for when she would be discharged. And I don't know that the issue of her payment for continuing on the case had been resolved. I did bring that up, and Judge Warning did state he was going to reach out regarding that. I don't see her here today, so I don't know if that's been resolved. But I'm not sure if she would need to continue on the case. She had been appointed previously and provided a report.
Thank you for that reminder. I appreciate that. I recall that she was appointed. I'm going to take a look at the order appointing back in, looks like September of 2022. As far as termination, appointment ends, it's blank. So it looks like she's still appointed at this point. So I guess I was premature in talking about a family court investigator with Jen Schaefer, so I'm going to retract that. Ms. Turnbull is still on the case. So I think what would be appropriate is just to set it over 6 weeks and have her just give a brief report of how she thinks things are going at this point. And then as far as Ms. Looney, as far as termination, ending of the child support obligation, is that a document that is that a form document, or is that something that I could just do a simple bench order and end the obligation?
A simple bench order should suffice, Your Honor, just so that it goes to the registry and GCS is made aware.
Okay, so I'll prepare that bench order that terminates Mr. Ruby's child support obligation as of today, April 24th of April 17th of 2024. And then I think that's it. Those are the 2 things that I'll be doing. Do you have any questions, Mr. Ruby?
Yes, sir.
Okay, Ms. Looney?
No, Your Honor.
Okay, great. Thanks for being here. That'll conclude down. Thanks.
Thank you, Your Honor.
Ms. Looney, is that all your cases? Ms. Looney is present, and Rebecca Mills. Can you hear me okay, Ms. Mills?
Yes.
Perfect. And is Samuel Mills on the line?
Yes, Your Honor.
Okay, welcome to Mr. Mills. Let me pull up the documents that were submitted so I have those in front of me. Okay, so I have those, a variety of documents in front of me. I see a parenting plan order that was signed by both Ms. Mills and Mr. Mills. And one question I had is on page 3 of the parenting plan, paragraph 4, where it talks about evaluation or treatment required. It says evaluation or treatment required, Samuel Mills and Rebecca Mills, and that to start and comply with treatment as recommended by an evaluation. And then the next box says, as follows, domestic violence treatment and love and logic for Rebecca. So what my question was, it wasn't clear to me, is that the evaluation of treatment for Samuel and Rebecca is the domestic violence?
Yes. I have 6 months of domestic violence treatment, and I believe Samuel has 12 months. So those both need to be in there.
Okay. And then when it says domestic violence treatment and love and logic for Rebecca, that's where I'm a little bit confused because it singles out Ms. Mills for domestic violence, but it doesn't mention Mr. Mills. And then I'm not sure if love and logic is for just Rebecca or for just Samuel or both or one.
So we both need to do the domestic violence treatment, but the love and logic is just for myself.
Okay, so on the bottom of page 3 where it says domestic violence treatment, I'm just going to put an arrow, put Samuel and Rebecca, and then love and logic for Rebecca.
Yes.
Okay, Mr. Mills, are you comfortable with that?
Yeah, that's fine, Your Honor.
Okay, so let me just note that here. Okay, so with the parenting plan, it's been approved and signed off by all parties, including Ms. Day, the guardian ad litem. And Ms. Day, are you on the line by chance? All right, there's no response. Looks like she's not. So I'll sign off on the parenting plan. Then I have findings and conclusions about a marriage, and it looks like that's been signed by both Mr. Mills and Ms. Mills. Any concerns if I were to sign off on that now, Ms. Mills?
No concerns.
Mr. Mills?
No concerns, Your Honor.
Great. I'll take a moment to sign that document. Signed. Next document I have is a final divorce decree or a dissolution decree that's been signed by Mr. Mills and Ms. Mills. Any concerns if I were to sign off on that order at this time? Ms. Mills?
No concerns.
Mr. Mills?
No, Your Honor.
Okay. All right. Thank you. I'll go ahead and sign that document now. Next item I have is a child support worksheet and a child support order. And that's been prepared by Ms. Looney. And I see Ms. Looney has signed it, and I'll double check with Ms. Mills. Did you receive a copy of those two documents?
Yes, I did.
Okay. Mr. Mills, did you get a copy of those two documents?
Yes.
Okay. And Ms. Mills,
Your Honor,
yes.
We did receive by email signatures of both parents for the worksheets and the order. But because the originals were already there, we were not able to get those to the court. So I believe the fastest way to resolve everything for the parties would just to be to ask them to confirm that they agree via Zoom, and Your Honor can note that without needing to have extra time to send those documents to you.
Sure, that makes sense. So Ms. Mills, so the net incomes, and Mr. Mills also sets Mr. Mills in net income at $3,587 a month, and Ms. Mills net income at $2,254 a month. Are those numbers that you're both agreeable to, Ms. Mills?
Yes.
Okay, Mr. Mills?
Yes.
All right, and then as far as the child support obligation, the amount, it also talks about uninsured medical expenses that you would pay your proportional share of your income for those. Any concerns with that, Mr. Mills?
No.
Okay, Ms. Mills, are you okay with that?
Yes, I'm okay with that, Your Honor.
Okay, same goes for work and education related daycare. And then the person paying the support is, let's see. Well, maybe you can just tell me who's the
It would be Mr. Mills, Your Honor.
Mr. Mills. Okay. All right. So those two documents, Ms. Mills, the child support order and the worksheets, having reviewed those, do you have any questions or concerns about any of those?
No, Your Honor.
Okay. Mr. Mills, same question?
No.
Okay. All right. So I will go ahead and sign off on both documents. And Ms. Looney, you mentioned rather than, distributing it and getting signatures and the like, just simply put agreed via Zoom.
I believe that would just be the quickest way to resolve this, Your Honor, if the parties will agree to that.
Okay. Ms. Mills, are you okay if I just put on both of those orders agreed via Zoom rather than having to send that out to you and get your signature?
Yes, please, Your Honor.
Okay. Mr. Mills, are you comfortable with that?
Yes, I'm comfortable with that.
Great. I will add that to that document. So all orders are signed, and those will be filed today. If any party needs a copy, you can certainly check with the clerk's office and obtain those. Ms. Mills, do you have any questions?
I do have one question.
Okay.
We were here a few months ago, and Samuel was asking, it was about no introducing new partners for a certain amount of time, and there is a 9-month court order. But in our parenting plan, which is more recent, we have agreed to only 6 months. So I guess I'm wondering about that court order. Would that still be in effect, or would our parenting plan like supersede that?
The latter, the parenting plan would supersede.
Okay, perfect. Thank you.
Yeah. Mr. Mills, do you have any questions?
No.
All right, those documents are given to the clerk. Those will be filed, and that'll conclude the case. And thanks everybody for your efforts.
Thank you, Your Honor.
Thank you, Your Honor.
Welcome.
Thank you.
And then Danielle Thomas, are you on the line today? All right, I can see Ms. Thomas is there looking for the unmute button, it looks like. So we'll just pause for a second.
I'm here. I'm so sorry, Your Honor.
Okay. All right, so Ms. Thomas is present. We're on today for a motion brought by Ms. Danielle Thomas related to a motion to terminate back child support and a petition to modify child support. I read over the information that Ms. Danielle Thomas provided the court, and I was looking to see if Mr. Thomas, if you had filed anything, and I didn't see anything in the case file when I was reviewing the case over the weekend and this week. Did you file anything by chance?
I haven't filed anything. I got stuff, paperwork showing like when she was ordered to pay child support and all that, and then the recent what I pay because I have kids too that I pay for. So I just got out of jail recently, so it's like that's why I couldn't appear before.
Okay. So you just were recently released from incarceration, and so now you're here. Were you planning on filing something as far as to express your? Because some people do it different ways. One is that you would file your documents so Ms. Thomas could see it and I could read it before we all came here, so everything's fresh in our minds. That's one way to handle it. The other way to handle it is you just give your information verbally here today. And sometimes that works. Sometimes that's not the best because it's new information, not only to me, but to the other side. And sometimes it doesn't hit right. But if we're given time to look at it, then it's sometimes easier to digest and understand.
Right.
So kind of tell me what your thoughts are with that.
Well, that's kind of it. Just she wanted back child support, not to pay back child support, and just the ruling was it before 2018? She just started paying child support. So whatever was ordered clear back in 2009.
Yeah. So there's the order back from November of 2007. That
2007.
The child support obligation that Ms. Thomas was to pay that, and so she's.
I believe you were his lawyer, to be correct.
Pardon?
I believe you were his lawyer at one point on this case.
I don't.
Yeah, I do believe so. You used to be his lawyer.
I had Chad Andy was my attorney, and then Andrew
Michael Evans
was my attorney. That was it in Washington.
There was a Michael Evans. I know who he was. I remember his face when he came on the stand today, or when he came in court today, because he used to be your lawyer, Daniel. I know for a fact. I've got paperwork submitting it. So.
Okay. So let me just double check that. I look at Mr. Thomas, I see his name, I hear his voice. I have zero recollection of familiarity with him. And I'm not discounting what you're saying, Ms. Thomas, is that I could have. I've been on the bench since 2009, since January of 2009. And so if I represented Mr. Thomas, I don't remember anything of that representation, whether it was a family matter or
it was very brief.
Or other. Pardon?
It was a very brief time. You were his lawyer just before Chad Zandy, and you ended up having to, it was a conflict of interest because there was a lawyer in your law firm that was representing me. So you ended up not being his lawyer, and he ended up getting Chad Zandy, I'm not sure how it would played out, if it was Andrea Blondin first or Chad Zandy, but I know you were briefly his lawyer at one point.
Okay. Well, yeah, I appreciate you raising that issue, Ms. Thomas. That's an important issue. I mean, it's an issue of, optics. If it's, you want the appearance of fairness, I think that's one of the bedrocks of our system. So, the concern is that if a person has represented, a person who's now a judge has represented one of the litigants in past, the concern is that there might be some favoritism or maybe actually a grudge. There might be a grudge too. I mean, it kind of cuts both ways, right? I mean, not all attorneys and lawyers and clients are best friends. Sometimes they part ways and they're not happy with each other. So I have zero recollection of anything about Mr. Thomas. And I would be quick to recuse because I think that appearance of fairness is really important. And if I had any recollection of ever representing him, I would be happy to recuse. But since I have zero recollection, I have completely neutral feelings because sometimes I'll come in and I'll see somebody and like I'll recognize them. And sometimes I'll have a very positive feeling because I've represented them or I've interacted with them in the past. And I let people know that. I say, hey, I have these just positive feelings toward this person, or and on the inverse, negative feelings. And I'll share that because I think that's important. Here, it's completely neutral with Mr. Thomas. I'm just kind of here. I don't feel
I respect that.
one way or the other. So at least from my vantage point, I think we can move forward here today with kind of that explanation and my leaning. If there's any question, I'll step aside for the appearance of fairness because I think it's that important. But here, where I don't have any recollection, I feel completely. I don't have any feelings one way or the other, and zero. Looking at him, it doesn't ring any bells. Not even.
I respect that, Your Honor. I'm sorry. I wasn't trying to be rude.
No. The apology is not needed. I appreciate that you raised the issue because it's an important issue and we need to address it because if you have concerns, we needed to hear about it. And so you shared those and I appreciate that.
Yeah, we can move forward. I'm sorry.
No. I appreciate you raising the issue. Very important issue to raise. So we're here with the motion to terminate the back child support. And I just want to make sure, Mr. Thomas, from your vantage point, what's your response to Ms. Thomas's motion?
So even like with the back child support from October 2007, she's ordered to pay, and then she just started in 2022 paying, nothing ordered more. And then like with my two kids I have 2 other sons, I still pay child support on them. If I get behind, they take it from my check or I get caught back up. I even have that stuff showing that. But it's like,
so hold on, Ms. Thomas.
But she's already paying child support. Then there was a sum for like 222 she was trying to go to from 300. Like, so I'm seeing this, but I was just like, she can't get out of what was already ordered back then. So I don't get what she's trying to do. Like with me, I'm incarcerated. I'm still reaccumulating child support. So when I get out, I still got to find a job. I still got to pay back child support regardless if I have a job or not, or I lost 2 jobs from the same freaking ordeal. You know, it doesn't matter. I still got to work and pay it.
Correct. If you have the child in your care, but in this case, Gunner was never placed in your care.
Gunner is now.
So hold on. I'm just gonna. I usually lay some ground rules. Is that I'm really good about letting everybody speak their piece, and so I don't allow interruptions. If one party speaks,
I'm sorry, Your Honor.
They go ahead and finish, and then the other person will have full opportunity to respond. So, Mr. Thomas, please.
Gunner is now, he's 18, almost 19. So he has moved out. He's graduated school. I mean, now he's out doing he was staying with her mom because he was getting into trouble in the county that we were living in, and he just wouldn't listen to me or mind me. He's being stubborn. So he kind of is doing his own thing, and he was living with her mom out in Idaho. And I was like, okay, you can go out there. That'd be better for you to get away from St. Helens, where you've been skipping school, having problems with friends and drugs. Like, this is a good thing to get away and hang out with family, even the mom side, because he didn't know that whole side. So recently they started seeing each other. I allowed this a couple of years ago without going through court ordered supervised visits and because I've done that with my kids, and it's not fun and it's not good for them. But I just don't get when I'm in jail, she's filing this stuff while I'm in jail, and then now she's already just ordered it. So I don't get why she's trying to get out of it. Because if I had the money, I'd actually use it towards him, because he's struggling in life too, to find a place to live and get around, and he's been in trouble through things. So it's like he could actually use the help too, and that's what I'd use it for if I got the money.
So let me ask you. There's Ms. Thomas in her motion. She indicates that Gunner was not with you from 2009 to 2024. Do you agree with that or disagree?
I disagree with that.
Okay. Were there times when he was with you?
So I was married again, but we're not going back over all that. I was married before, and then I went through a divorce, and there was court issues where I had stuff there, and I went through all of it and passed all of that. And that still never changed placement of where Gunner was. Gunner was still taken care of. It was with my ex-wife. After her, we got divorced. I got married, had another kid. And then he was with her. And there's a point where I didn't have him for a little while because of stuff that was going on. And then after that got all cleared up, then I got him back, and I started doing my normal life. And then I went through another divorce, and I had my other son, Isaiah, his brother. And so I was doing that. And then I had my third son, Hunter. So it's like I was part of all their lives, taking care of them too.
So what do you think, if you were to give an estimate as far as the amount of time, months or years, weeks, that you had Gunner in your custody from, say, 2009 to 2024?
So I think it was about probably 2 years. There was a gap of maybe 2 years where I didn't have him, but not from when I got custody to him to when he was first born, clear up until now. Like, he went and stayed with his mom a little bit, then he was couch surfing from here to here. But that was after he was 18, or right around there, right when he was 17 and a half, almost 18.
Okay.
And then at that point, that just this whole time, the sheriffs have been up my butt. Like when I got custody of Gunner over here in Washington, like Washington is totally towards the kid and him being protected and seeing both sides of the parents. And she was just supposed to do a couple things. And she never did that the whole time. And then she still sees them. They're like with me in Oregon, like I have my kids and I've only lived over here 9 months, got a DUI over here, still got full custody of my son, right? At that time, and my brother died. Still got full custody of my son, still able to raise him. And then I see that she's even getting help from the state and everything this whole time with her other kid that's autistic. And I'm like, man, all these years knowing that she had a kid that still had the same struggles like my son does, and I could have had that support in school, because like trying to deal with IEP and deal with the teachers and being a guy trying to deal with this, you wouldn't believe how much garbage it was just to go through to even get them to understand him and not like, oh, just pass him off so he gets an education, you know? I even brought him to work with me, took him to work, showed him different types of jobs I did. He got on the job training.
Okay.
So it's like, he's a very well-rounded kid.
Mhm. Okay.
But I mean, I've raised him. I mean, you can ask him too, but it's not, the whole thing isn't about the money. That was ordered just like me. It's ordered whatever, if it's minimum wage or if I made $20 an hour, that's all I've ever done in my life. I mean, you can only take so much. Like with her, it's the same thing. She has other kids, but even what she's applying for, like she's claiming food stamps for Gunner. Well, Gunner was there. And then he needed that, and he didn't even have food stamps. He couldn't even get it when he was couch surfing. I'm like, well, here, I'll help you out. But
No.
things like she's doing there, and then saying that her girlfriend is her sister, and that's not even her sister. That's her girlfriend. That's living with her. It's like,
Okay.
and then she changed her last name back to Thomas towards the end of when was this, in 2022, 2023, when she was married already before. I don't get why she was even doing any of that. Like, to go back and forth with your last name when you had 3 other kids prior. Why don't you keep one of those last names and go back to your first kid? I don't get the whole cause of that.
All
And in
right.
the state of Washington, when this first went, she was found out to be lying, being a habitual liar. She was found in these courts to lie on record.
All right. So let me, before I hear from Ms. Thomas, so this is kind of what we were talking about at the initial get-go, is that I've had an opportunity to read what Ms. Thomas has to say. You've had an opportunity to read what Ms. Thomas has had to say. And then I get to hear for the first time kind of what your viewpoint is. And Ms. Thomas gets to hear for the first time kind of your official viewpoint at this point. So to be honest, it's a little hard to take in, because traditionally when I prepare a docket, I'll read both sides, right?
Yeah.
And I'll have an opportunity kind of in the calm of my office to kind of weigh things left and right. So I'm kind of the opinion of, because you raise a lot of important issues that I haven't given much thought to. And if I do it on the fly, I don't necessarily know if that's the best way to proceed. So I'm kind of leaning towards giving you an opportunity to submit documentations, a declaration to kind of spell out and support your positions. So I can see that, and Ms. Thomas can see that. And if she wants to reply to that, then she could submit some documentations of giving her viewpoint on what you had said.
Oh yeah, and I was just able to get my taxes done to show my last 2 jobs of the last year and everything too. So it's like I just got this together before the court date, and I have it here, but I just didn't submit it yet.
Right, Ms. Thomas?
So
Go ahead, Ms.
So you're
Dacre.
giving him a chance to get his stuff together when we've already been to court 2 weeks ago and he was a no-show, and I called the courthouse where he was at court. They said he could have been there via Zoom. So now we're taking this out another 2 weeks or however long, because we've got to get proof of what? The fact that he didn't have our son, the fact that he's misusing my child support money that I'm currently sending him on his addiction. What are we doing? This is not okay. I'm not okay with it.
Okay.
And I guess that if we have to, I will do the proper antics to go and channel how I need to, if I don't agree with this court hearing.
Right. Yeah.
Or I would just rather have you stricken off as a judge, because I feel that this has gone on too long and I'm just tired of it. He's taken the money that I'm giving him every month that I could be using for my disabled children. And you see I've submitted you evidence after evidence of what he's doing with the money, of petitions, of declarations. And you're just gonna be like, oh, Daniel, let's waste Daniel's 2 weeks and get proof that you don't need. I'm so frustrated, Your Honor.
Yeah, I hear your frustration, Ms. Thomas. One of the bedrocks of our system is due process. Due process is basically comprised of an opportunity to have a fair hearing, which means notice and opportunity to respond. So opportunity to respond, there's a lot of times there's default judgments that happen where people just don't show up, and so we just sign defaults. There's oftentimes life is not a clear cut from point A to point B. And so generally we try to err on the side of giving everybody a voice, because if people feel that their voice is heard in court, then they feel like they've, win or lose, they feel that they got a fair shake. And that's really what the system is about, is giving opportunity for every voice to be heard. Does it have to be, are there some reasonable time limits on that? Sure. You're talking about a 2-week set over, maybe waiting a month for issues that stem back from 2007. I think that's reasonable. I think a 2-week set over is a reasonable period to allow you the opportunity to hear what Mr. Thomas has to say and allow him an opportunity to say, and for you to rebut that. I think it's reasonable that 2 weeks is not bending over for anybody, especially when you're considering the request, which stems back to 2007. So I'll set the matter over to the.
Can I have a different judge, please? I don't want you as on my case.
It's too late. You can't get a ruling and then say, I want to switch. So at this point, no, that request is denied. So I made it because I made a discretionary decision to continue the matter prior to that request being made, and the prior record, which I had made on at the beginning of the hearing, indicating zero recollection of any representation of Mr. Thomas. I also checked the case file for notice of appearance, which all attorneys do if they represent somebody, and I did not file that, at least in this case. So if we can set it over to 2 weeks, May 1st, we're not available. That's judicial conference. The following week is available, so that would be on May 8th. So we'll set it to Wednesday, May 8th at 9 o'clock in the morning. And Mr. Thomas, if you want to respond in writing, you'll need to submit your documents to the court with declarations supporting them, and then serve those or give copies of those to Ms. Thomas. And then she would have an opportunity to respond and file her response, and she'd have to give you copies of her response and file hers with the court.
So which address is she using? There's 3 different addresses on that paperwork.
Daniel, you have my address. Don't act like you don't have
Why
my
don't you
address.
text
So
me your
wait. We're not going to do this.
Yeah.
You both, when you speak, you'll speak to me and to me only. You will not speak to each other in the hearing. So what I show here is that Ms. Thomas used an address in Portland.
Street. That's correct, Your Honor.
That's the most recent filing. That's where documents can be sent for her review.
Now, can I ask a question?
Please.
So I do apologize for my frustrations. I want to start off by saying I'm sorry.
It's okay. It's fine to be frustrated.
So I've got 2 kids that have disabilities. And as much as I hate, I am struggling myself. And so it's just like, I guess maybe I don't understand what's going on. Like, I don't get what, are you just giving him the opportunity to giving
him an opportunity to have his voice heard and for you to respond to his position. So the court will be well informed of what the issues are from both perspectives. And
now, if I needed to get his ex-wife subpoenaed into court due to the fact that my son was with her for an extended amount of time, several years to be exact, then this is the time that I can do that if needed, right?
So generally, these type of hearings, they're done on declarations or written documents. So if you want to submit any documents, you can. You need to make sure that copies are given to Mr. Thomas so he can respond also.
Okay, so written declarations, is that correct? I'm just trying to understand, Your Honor, that's all.
Yeah, that's how people's voices are heard.
How I was served while I was incarcerated. When I was in St. Helens, Columbia County Jail, I got served this paperwork inside the jail, and they wouldn't even let me appear video WebEx or calling in or nothing. So I was like, how was I getting served while I was in jail?
So it's not uncommon. People are served while they're incarcerated. That happens with some regularity. I see that regularly.
Yeah.
So you'll have an opportunity to submit your documents, and then we'll be here on May 8th, 9 o'clock.
But all this from up in 2007, 2022 was already ordered past then in 2007. When Chad Zandy had it, I believe that's when all this was ordered. And then just like, I'll submit this. It shows that she's supposed to be doing $320 a month. And then the state finally caught up to her when she changed her last name from Hudson back to freaking Thomas. And then now she's owed this. So
right. So these are all issues that we'll talk about on May 8th.
Okay. I'll just submit all the stuff I have from Washington and all that.
Yeah. Whatever you feel is appropriate, you can submit that information and Ms. Thomas can supply her response to it.
You have a copy of the court date?
May 8th. We can write it down.
I didn't bring a pen. I forgot one.
Sure. All right. So we will see everybody on Wednesday, May 8th at 9 o'clock in the morning.
Now, there is one more question, Your Honor.
Yep.
I did file my tax return, and I have filed the conference board to have them give me half of my taxes back. Currently, my son is very sick, and I've got medical documentation supporting that I need that money for my son. Is there any way, like, you can, there's really no way you can do anything until you have your ruling. Is that correct?
Yeah, for the court to make a decision on any issue that's important to the parties, both parties have opportunity to raise it and have their voice heard, and then a decision would be made. So any decision related to taxes would be premature today without both parties having an opportunity. So if that's something you think is important, you can certainly raise the issue via motion and note it up for a docket and give Mr. Thomas an opportunity to respond.
Okay, now, since I'm self-representative, you said write it up for what, Your Honor? A motion?
Yeah, anytime anybody asks for something from the court, they want something, then it's usually brought forward in what's called a motion. A motion is just a request. It's a petition. It's a request. So generally,
Okay.
it's if a person is asking for a motion for more parenting time, they'll say it's a motion for more parenting time, or a motion to change child support, or a motion to do X, Y, or Z. Okay.
Fair enough. Thank you, Your Honor.
Any questions, Mr. Thomas?
No.
Okay, we'll see everybody on May 8th at 9 o'clock in the morning. Thank you.
I don't know how to log off, Your Honor.
That's okay. I can help. 08.
Thank you.
If Rebecca Castiato is on the line.
Yes, I am, Your Honor.
Okay, welcome to you. And Keegan Miracle, are you on the line?
I'm here, Your Honor.
Okay, welcome to you both. We're on for two matters noted today. One is a motion for contempt related to that's brought by Ms. Castiato related to child support. And the other is a motion for adequate cause to modify a parenting plan, also brought by Ms. Castiato. So I'll hear first from Ms. Castiato and then from Mr. Miracle.
Hi, yes. So the initial order in motion, or the proposed parenting plan that I filed, started back in November due to when Soren had returned from his father's care with multiple bruises and stating that his father was punching him. I had taken him into the hospital, and by medical examination by a child abuse expert, it was stated that the bruising was consistent with what Soren had stated. CPS and police investigations have been ongoing since. I did just hear back from CPS yesterday, and they're coming to see all my children today, and then they're closing the case as founded. So the abuse has been founded.
How do we, is there anything written that says that?
Not yet, because she's coming to see the children today before she can close the case.
Okay.
So after today, hopefully, I don't know if she'll give me something when she comes out this afternoon, or if she's going to send me something in the mail, or I have to go pick up something. I'm not sure exactly. But yes, and then with the police investigation, I did call and leave a message for the prosecutor, because last time I spoke to them, they said they were assigning a victim's advocate to the case. But that's been about a month or so since they said that, so I haven't heard anything since. But as to my knowledge, they're supposed to be putting a victim's advocate onto the case.
Okay.
And then concerning the contempt, I know in Keegan's declaration, he did state he was working at Chevron. I'm kind of curious as to those dates because child support hasn't been received in a while. I'd also like the courts to know that I never withheld any mail, nor did I open an IRS investigation. That sounds like something that I arrested. I'm also curious as to who claimed him on taxes last year, because to my understanding, if you owe back child support and you have money coming back, the state will withhold the money. But nothing like that ever happened. There was never any large amount of child support taken or paid applied to the case. So in my opinion, I think he had somebody else claim the child as a means to avoid the child support arrears. So I'm curious as to who claimed him last year.
Okay. Thank you, Ms. Castiato. Let me just ask you a quick question. On your motion for adequate cause and to modify the parenting plan, the current parenting plan was issued in January of 2022, where it's roughly a 50-50 plan, and you're designated as the primary custodial parent, correct?
Correct.
And then your request to change the parenting plan, tell me what that is.
I'm just trying to protect my child. Abuse has been an ongoing concern since 2020. There's been multiple CPS investigations, multiple injuries. My child has abstained in his father's care, unexplained and suspicious injuries. So I would like to have full custody of my son. I believe in his father's care. is very detrimental to his health and well-being.
Okay. All right. Thank you. Okay. Then one last point of clarification before I hear from Mr. Miracle. Ms. Casciato, in your motion for contempt related to child support, that stems from a December 2021 order that requires $531 a month to be paid. And you indicated that roughly, it looks like Mr. Miracle has made 5 out of 27 payments. In that I listed here, there was 1 payment missed in 2021, 12 missed payments in 2022, 7 missed payments in 2023, and 2 missed in 2024, January and February. So in total, that's roughly missed 22 payments at $531, comes to a total of $11,682. I know you have a different figure on your proposed order, so I wanted to ask how you came to that to your figure.
That was what I had gotten off of the child support website. It stated on there the back child support arrears and what he's supposed to pay a month. Yeah, he hasn't paid anything for this year at all. I haven't received anything in a long while. I've also been on TANF, so I know the state's probably added some on there for what he owes the state. I'm not quite sure how they divvy that up.
Okay. All right. Thank you. Okay. I'll turn the time to Mr. Miracle, please.
Okay, well, I haven't heard anything from CPS nor the police investigation. Like I've had no communication with them. They've never called me. I've had trouble getting a hold of them. So I've had absolutely no input on anything on that end. Okay. As per the tax situation, it is when COVID first hit back in 2019 is when we had initially broke up and I had already filed my taxes. I've been in contact with the IRS. I'm trying to iron everything out. Through the entire there was an investigation on the case that was requested by an outside source that was confirmed. And I believe it was Rebecca Casciato. They couldn't verify that, but there's no other person that would have been trying to interfere with that.
And that's related to the taxes?
Yes, sir.
Okay.
Given at that time. And so what the whole deal was, they made it so I couldn't claim my son because there was a dispute that I was eligible to claim him. Okay. So I'm still in the process of trying to get the paperwork that there's a form that I have to fill out that I have to provide the information that like his birth certificate, that I'm on it and everything like that before I'm eligible to claim him.
Okay. And then what's your stance as far as child support payments? There's an allegation that they failed to do that for a number of months.
Well, the child support initially was when the child support was when you guys set it in motion, I was already $5,000 in the hole. Mm-hmm. You guys backdated it to I'd like to say somewhere in 2021 or previous. I'm not entirely sure of the dates. Last year I was working at Chevron. There was a number of issues, including our store being robbed at gunpoint. So I felt it was detrimental to my safety to get out of there. There's a number of security concerns as well, such as non-working cameras, me being there at night, no locks on the bathrooms. There was many overdoses in the bathrooms there. So it was just not a good place for anybody really to be. And since then, I was looking at that as a temporary job. I was initially trying to go into the military, and I was in communication with Rebecca about that. I'd already taken steps. I went and got my GED, went and took my went and took my pre-ASVAB. I've met with my recruiters, and as of this point, I'm kind of at a standstill until this whole police investigation gets until I know what's going on with the police investigation, because I can't have pending charges on my case.
Right.
So my recruiter just told me to, once that gets all settled, to get back to him. And then we can continue on with the enlistment process. I was trying to initially enlist so I can actually get caught up with child support, and I can, provide a future for my son, because I'm not with anybody. I'm having to do everything on my own financially, everything. so I don't have that kind of support. And as for like the jobs I'm able to get, the child support I believe was rated for around $20 or maybe 20 to 23. And the jobs I'm actually able to get right now, because I do not have my license, I'm still trying to get that back. So I can't get any of the construction jobs that are paying higher at this point.
Okay. Okay.
And I'm just trying to do everything that I can, and this has been an ongoing issue. This is not me. This is Rebecca throwing mud at the wall to try to see what sticks. And I don't understand how she can continue to do this and get away with it. I'm asking for everything to be denied until the outcome of, or until we know what if the prosecutor is going to decide to press charges or not with the assault case.
Right. Okay. All right. Thank you. So regarding the motion for adequate cause to modify the parenting plan, I'm going to make a finding that there is adequate cause to modify the parenting plan. I recognize that there's still outstanding issues related to the investigations and the like, but I think there's enough there to grant the motion for adequate cause to modify the parenting plan. As far as the modification of the parenting plan, we're going to have to do this kind of piecemeal, at least in my mind. It sounds like there may be a decision from CPS coming forth fairly soon, but nothing's guaranteed with that. But there's back in December, Mr. Miracle's parenting time was suspended pending outcome of this, and it's been a very long time, obviously. So I'm going to continue that restriction of no visitation until the CPS and law enforcement have completed their investigation and we have updated information from both, at which time then we could take a look at any type of modification going forward with the case. And like I said, that may involve 2 or 3 steps or maybe more. So it's kind of undetermined, uncharted territory at this point because there's information we don't know yet from CPS and law enforcement. But nonetheless, I do make that finding of adequate cause. Regarding the motion for contempt, the court looks at the December 2021 order where it orders Mr. Miracle to pay $531 per month. It sounds like, Mr. Miracle talked about the Chevron and sounds like a very traumatic experience. And so he exited himself from there based on that experience and the maybe lack of feeling of safety therein. Nonetheless, there's been a kind of a pattern of non-payment. And according to my calculations, there was, from December of 21, when the order was in effect, till when the motion was filed, which was February or March, that's a total of 22 non-payment months for a total of $11,682 of non-paid child support. So I'll make that finding of contempt that there's been a willful failure to pay that. And I'll enter the proposed order that was submitted by Ms. Castellano. One other thing that I still need to do is an order on adequate cause. I'll need to prepare that. So I'm just giving myself a quick little note to prepare that and file that. Cause. And then I'll ask Ms. Castellano, do you have any questions?
I do not.
Mr. Miracle, do you have any questions?
This realistically shouldn't be happening. I'm already, honestly, Your Honor, I really would have rather tried to keep this out of court, but I have been seeing a counselor for mental health due to all this, for PTSD, and it's been a long time. I've been struggling with it for a long time. Yeah. And so the unwillfulness to pay, it's my social anxiety, Your Honor. Yeah. I can provide medical documentation stating that. Okay. I'm not trying to go to jail for something that should not be happening. And I'd much rather try to keep my mental health out of the court because I'm trying to be better and I'm trying to get better.
Right. Yeah, and I appreciate that input, Mr. Miracle. I saw that we've been here a couple of times on the motion over the past couple of months. I did read your declaration that you filed, looks like on April 2nd. That talked about, getting the GED, the enlistment with the Army, information related to that, and the other items that you brought forward. So I've reviewed that position. This is the first I've heard about, the social anxiety and the like. So taking that into consideration, I still, as far as the contempt, if somebody's in a position where their mental health or physical health is preventing them from providing support as ordered, one of the mechanisms of relief is to come to court and ask, hey, judge, this is what's going on. I've got these concerns. I have these limitations based on mental or physical health. And could you please modify this child support? So that's one way that people that when they're suffering through things, they can seek some relief, and often that's given. Here, where I wasn't apprised of that or any motions related to that during this period of time from December of 21 till now, really kind of my hands are tied at this point. So,
well, Your Honor, it is an irrational fear. Like anything that I've said or done, Rebecca has used against me. So it's one of those things. I was assaulted by Rebecca. She did go to jail for 2 counts of an assault, and there wasn't a protection order in place. It's a point of it's a very touchy point for me. It's a high stress point, so I try to avoid it as much as possible. And I'm trying to be normal as much as possible, but with all these court cases, it's high stress, and I do shut down when it comes to it.
Mm-hmm.
But I do know, or I do understand the importance of getting everything in. I mean, I am, the only thing I can do is, I'm just trying to ask if I can maybe set this out so I can get my paperwork set in there, so you guys are aware. But
yeah, so as far as a request to set the matter over, what I've done with any contempt order, there's a purge condition, and here the purge condition to purge the finding of contempt is for you, Mr. Miracle, to timely pay monthly child support obligation for a period of 6 months. If you do that, then the contempt finding is purged, and it's that kind of, it doesn't necessarily correct the issue, but it at least removes the contempt. So any efforts to follow through on that is definitely appreciated. I will file this contempt order, and then I will also prepare and file an order on adequate cause. So I think at this point that concludes the hearing. I'll ask Ms. Casciato if you have any questions.
I do not, Your Honor.
Mr. Miracle, any final questions?
Well, so I am able to talk to my son Monday, Wednesday, and Fridays still at the same times, 4 p.m.
I think that was we had discussed that previously, correct? As far as kind of an interim order, Ms. Casciato, is that accurate?
Yes.
Okay. So with that adequate cause, so it was Monday, Wednesday, Friday, did you say, Mr. Miracle?
Yes, sir.
And what were the times again?
4 p.m.
At 4 p.m. Okay. Then that's for phone visits, correct?
Yes, sir.
Phone or video. Yeah. Okay. So that. Oh, sorry. Go ahead.
Oh, phone and video. Rebecca doesn't live in a very a connection savvy place, so it's hard to get video.
Oh, okay. Yeah, as far as the adequate cause, I'll make a finding of adequate cause. We'll continue the phone/video conversations, visits between dad and child, and then once we have information on the official written status, either from law enforcement or CPS or both, that should be filed with the court, and a motion should be brought forward to look at parenting time. So I'll leave that up to the parties to do that, and that'll conclude the efforts for today. Thank you. 08.
Thank you, Your Honor.
I believe I saw Ms. Rodriguez. You've been on the call the entire time. Can you hear me, Ms. Rodriguez?
Yes.
Okay. Welcome to you. I'll ask if Kara Kwasnick is on the line. Kwasnick, thank you.
No, she's not on the line as far as I know.
Okay. So let me ask you, Ms. Rodriguez, your motion relates to, you're the maternal grandmother of the child, correct?
Yes.
And your daughter is Ms. Kwasnick.
Yes.
Okay. And Mr. Frank Guland is deceased.
Yes.
And his grandfather is the individual who gave the DNA sample.
His father is.
The grandfather of the child. But
Yes.
the father of Frank gave the DNA for the paternity testing.
Yes, and he's listed on the death certificate as the father of Frank.
Right, I did notice that.
Okay.
So one thing I wanted to ask you. So I reviewed your case fairly carefully. And one thing that it struck me is this. Number one, I want to talk to you first about service of the documents. So on April 8th, you served the documents on, I believe, Ms. Kwasnick.
Yeah.
You're asking for a summary judgment, a motion for summary judgment, which is basically said, hey, there's really no reason for this to go to trial. All this can be sorted out and resolved here at this early stage of the proceedings. And so because it's a fairly significant step, saying we're not going to have a trial, but we'll just resolve it now. There's longer periods of time that are required for a person to respond to a summary judgment motion. So summary judgment motions have a longer lead time. So for example, if it's Civil Rule 56, and Civil Rule 56 requires 28 days notice, calendar days of notice from the time somebody gets served until the case can be heard in court. So we're obviously before the April 8th plus 28 days puts us sometime mid-May, roughly. So as far as timeliness, we're here too early. And so we're not necessarily in a position to move forward because the requisite time period has not elapsed from time of service for Ms. Kwasnick to respond, and she may not respond.
I'm sorry, my daughter had gone to court for this matter on December 27th.
Okay.
She informed me, which she misinformed me, that the judge was holding the case over and that I'm the one that had to appear. So as I went to the court clerk's office to put in an appearance for myself, they said, no, that's not what happened at all. And so that's why I filed all this. My daughter had already had a complete copy of this, but with her name as petitioner and my name wasn't on there. It's just the same exact paperwork, but with my name on it and her name as the other party respondent.
Right. So that's a separate case, but and all the same documents, but just a different title and a different number.
Yeah.
Okay. Another question I wanted to ask you, if I could, Ms. Rodriguez, regarding the motion for summary judgment, that document, and also a copy of the DNA testing. Did you serve either or both of those documents to Ms. Kwasnick?
Yes.
Okay. Did you file
a copy of everything she got?
Did you file a declaration of service that shows me that? So declaration of service is a fancy way to say, yeah, on such and such a date, person X served to Ms. Kwasnick the following documents and handed it to her personally or mailed them to her, what have you.
I turned in that you got served Texas, I think it was, served her a copy of the paperwork.
Yeah, and what they said is that they gave her a copy of the summons and the petition to decide the parentage.
It was everything.
That may be the case, but what I see in my case file, which I have to go by, is they said it was only the summons and the petition to decide the parentage. So they didn't tell me that they also gave her the motion for summary judgment and the DNA testing results. And that's probably not the happiest news I can share with you, but it constrains me of what I can do today, because one is the 28-day rule as far as service for motions for summary judgment, and then also the service of all documents. And they very well may have, served all the documents, but they didn't list them all, and that's problematic, at least from my standpoint in moving forward. So
yeah, because I gave them to the FedEx place. The FedEx place photocopied everything, and I was never allowed to have the documents back to separate them. And so FedEx just came and picked them up and delivered them to You Got Served Texas, and then they delivered everything to my daughter. So they probably didn't know that there was multiple things in there.
Yeah. So that's kind of the issues that I have that prevent me from moving forward today. So the case is still open, but those deficiencies have to be rectified first before we can move forward.
And what is it that I need to get her served with again?
So they indicated that she was served that, so there needs to be service of all documents that relate to your motions or petitions. So one, you have to serve the summons, you have to serve the petition to decide parentage, and those have been done. So those have been submitted. And then your motion, a copy of your motion for summary judgment has to be submitted, and a copy of the DNA testing results involving the paternal grandfather of the child.
So a copy of everything again, pretty much.
I mean, that's one way to approach it. That would be more thorough and sure.
I can't afford it. That's the whole issue. I'm not getting any help with child support from my daughter, and my granddaughter's angry because she has no parents.
Right. Yeah. So, also, just if you want to take note, these are some options of things you can look at that may provide you some assistance in looking at the case. There's the Revised Code of Washington, 26A 440. That's going to be an important provision for you to be familiar with. So you might want to write that down.
26A 440.
Right, Revised Code of Washington. And that refers to a concept that's referred to as standing. Standing is a fancy term, an ability or appropriateness of one party to bring an action forward. So make sure you're familiar with that, because that'll be something that may come up. And then the service issue, taking care of that, and the lead time of the 28 days. And that's Civil Rule 56. Civil Rule 56.
So how do I get another court date?
So generally, we're not really sure how long it's going to take for the service to occur. So generally what we do, we leave that up to you to kind of calculate timeframes of, with the service people, how long they think it'll be. And then they give you their return of service. And then you kind of make a best guess estimate of when all that will take place and everything will be served. And again, also calculating the 28 days for the motion for summary judgment from the time that she served, and then note it up for what you did before, a note for a motion docket or a family law calendar notice where you say, hey, we're going to come here on such and such a date to decide parentage and the like.
And I've asked for absolutely nothing in there, just for her dad to be added to the birth certificate.
I recognize that, and that's a very important thing to address. But before we can get to that meaty issue, we have these preliminary issues, which are the due process issues that really I'm constrained by. I have to follow those. I can't move forward unless there's proper service of all the relevant documents. If they're
and
out,
Tara has to be at court too.
Pardon?
And my daughter has to be at court too.
No, if she's served with the documents and given notice of a particular date, she's free to come and express her opinion, but she's obviously not required. And if she doesn't come, but she has been served and given notice of the date, then the court just moves forward without her input.
Okay.
All right. So we'll leave it to you to choose a date that fits within those timeframes of the summary judgment and make sure that all the appropriate documents are served.
All right. Thank you.
Okay. Thank you, Ms. Rodriguez. All right, so that concludes the matters that were docketed for this morning. I'll just double check with those that remain on the Zoom call if there's any matters that you expected to be called but have not yet been called. All right, not hearing any. That concludes the morning docket, so I'll end the Zoom call at this time. Thank you.